program today, we'll be getting to receiving a briefing from the Department of Justice on 2 international conventions, and thereafter we'll then look into the reports of the committee. Just in terms of the first presentation by the department, it will be on the International Convention on the Suppression and Punishment of the Crime of Apartheid. Members will note that this was adopted by the General Assembly of the United Nations on the 30th of November 1973. And this international convention is tabled in terms of Section 231, subsection 2 of the Constitution. And in terms of that section of the Constitution, our members, this international agreement only binds the country after it has been approved by a resolution in both houses of Parliament, the National Assembly and the National Council of Provinces. That being said, Deputy Minister, let me then hand over to yourself and the department then to take us through in terms of the convention. Deputy Minister.
Thank you, Chair, and good afternoon to the honourable members. I am joining you from Dar es Salaam, where there isn't load shedding. I'm here for a conference, yeah. So I'm not in the country, although I'm with you virtually. I'm joined. I think I see the Director General, Advocate Mashabane. Tandeka Luchisa, and I did see, although I can't see him now, Mr. Malisela Leso, also from the International Relations section of the department. So they'll do the department will do the presentation. I just wanted to say a few words beforehand on this particular treaty. As you've said, it was adopted by the General Assembly in 1973, the International Convention on the Suppression and Punishment of the Crime of Apartheid. The issue would be, why are we wanting it ratified? Why is government wanting to ratify it now? And initially, I think it wasn't moved on because there was a perception of apartheid being over. However, I think the important things to point out are that the crime of apartheid isn't apartheid as we know it specifically. It's in Article 2, and the definition of the crime of apartheid shall include similar policies and practices of racial segregation and discrimination as practiced in Southern Africa. And it shall apply to the following inhuman acts committed for the purpose of establishing and maintaining domination by one racial group of persons over another racial group of persons and systematically oppressing them. And it's things like, they then go on to list the denial to a member or members of a racial group or groups of the right to life by their murder, deliberate imposition on a racial group or groups of living conditions calculated to cause its or their physical destruction in whole or in part, and any other legislative measures and measures calculated to prevent a racial group or groups from participation in the political, social, economic, and cultural life of the country. And there's sort of further detail on that. And there's sort of more exploitation of labor of members of a racial group, etc. So it is actually something still relevant. We might have no longer have apartheid, but it's possible for similar things to be done in other parts of the world. And there are international instances one can think about where there does seem to be suppression of a racial group. So that's the one aspect. The other aspect, a reason for wanting to proceed with this, is that within our own country, there does seem to be some revisionism or denialism that apartheid was effectively a crime against humanity. And because of that, we also think it is important that South Africa as a country state unequivocally that apartheid is a crime against humanity and adopt this treaty. I'll pause there and then ask, I don't know, protocol-wise, DG, I don't know if I should go through you, but otherwise to Advocate Lujiza to lead on the presentation. Thanks, Chair.
Thank you, dear.
No, thanks, DM. I think DM has covered the high-level issues. Then I'll ask the colleagues to just proceed with the technical presentation. Thank you very much.
Good day, DM. Good day, DG and members. This is Malesela Leso here. I'm trying to see if I can fly to the presentation, but I'm not sure if.
Maybe, Chair, if I can ask if Mr. Leso can be given sharing rights.
I see somebody is already put up presentation. Gershwin, maybe give us an indication if Advocate Leso can get sharing rights.
Is it visible?
And sorry, Malisela, your sound isn't that good. Maybe if you can try and get closer to the microphone. And now the screen seems to have frozen that we have.
Yeah.
Chairperson, let me see if I can share from my side.
But something's on the screen at the moment.
Yeah, it's on the screen. It just needs to be moved through. I don't know if Malisela, if you can operate it.
Okay, I'm not sure what's going on. Okay. I see Malisela is not on the platform anymore. Oh, he is. Well, we can't hear you at all.
Okay.
DM, I'm not sure how we can deal with this one. Is it?
Chair, you've now gone.
No, I'm still on the platform.
Okay.
I'm just wondering, is he going to do the presentation on the other protocol as well?
Yeah, I think so.
Okay.
Advocate Lujiza,
excuse
your
me,
mic is on.
sir.
Yeah.
Yes, I'm trying to find my hand. I absolutely can't find it. I'm sorry, DM and Chairperson, for interjecting. If someone can help flag share the presentation, then I can just take it through. I can make the presentation now that Malisela seems to be having a bit of a problem. I think we are experiencing load shedding.
Okay, no, thank you, Advocate. I think the presentation.
Yes.
Yeah, I'd suggest that Advocate Luchisa does the presentation. Malisela, there's something seriously wrong with your sound, so we can't hear you.
I'm having the difficulties, or the presentation is.
Yeah, but Malisela, I think let Advocate Luchisa do it because your connectivity is bad. Advocate Luchisa, can you take us through? Yeah.
Yes, thank you very much, DM, and thank you, Chairperson and members of the committee. Can you, next slide, please? Okay, this slide simply outlines the presentation outline. We won't waste time on it. The documents that have been attached to the presentation are listed there, which includes the text of the conventions and the legal opinions from both the DERCO and Justice Oxler, and the letters to the relevant chairpersons. Next slide. Okay, in summary of the convention has its roots in the opposition by the UN, as the DM has explained, on the racial policies of the then South African apartheid government. And it was adopted in 1973 and came to force in 1976. There are currently, as of August this year, 110 state parties to it. Palestine was the last to accede to the convention in 2014. And the convention basically declares in the main apartheid as a crime against humanity. And members of parliament will recall that South Africa already has jurisdiction in its domestic law over the crime of apartheid by virtue of incorporating parts of the Rome Statute of the International Criminal Court into our law. So the crime against humanity is already explained and is already incorporated into our law. Then next slide, please. So the strategic focus is that the accession to the convention is in accordance with our international obligations and in line with our foreign policy, because we've already acceded to the ICED, which is the Convention for the Elimination of All Forms of Racial Discrimination. And therefore, this will just be an addition. And as I've indicated, we've already incorporated the issue of apartheid as a crime against humanity. And this is also aligned to the MTSF Priority 6, as indicated, of social cohesion and safe communities and a better world and a better Africa. And furthermore, as indicated there, the accession will be in line with the various policy documents that we have, the National Action Plan for Racism, the Promotion of Equality and Prevention of Unfair Discrimination, the PEPUDA, the National Development Plan, and our goal, or one of our strategic goals, is the Department of Justice to advance constitutionalism, human rights, and the rule of law. Next slide, please. On this slide, the main thing is that the Article 2 defines the acts and practices, the various acts and practices that actually constitute the crime of apartheid. And some of them are, as they are written there, that the denial to right to life and liberty, the deliberate imposition of living conditions calculated to cause destruction, the prevention of a racial group from participating in political, social, economic, and cultural life. One of the acts that was highlighted by one of the state law advisors was one which is contained in Article 2, but sub-Article D, which is the expropriation of landed property belonging to a racial group or groups or to members thereof. And we believe that they highlighted it because of the issue of the expropriation of property. But this, of course, is in a totally different context where it's directly towards a certain racial group and for the sole purpose of actually excluding them. So this is in terms of the apartheid and not in terms of the normal expropriation of land or anything else that's contained in our constitution. Next slide, please. The constitutional implications, as it stated that the convention supports the implementation of the rights as contained in our constitution, and both the DERCO and Justice State Law Advisors have indicated that it is in line with our domestic law and international obligations. Of course, there are no financial implications. And since the Committee on the Suppression of the Crimes of Apartheid is no longer active, there will be no obligation to draft country reports at this, towards this convention. So it is mainly to simply assert unambiguously apartheid as a crime against humanity, and to show our support in the international fora. Next slide. We therefore recommend that Parliament approve that South Africa accede to the Convention on the Suppression and Punishment of the Crime of Apartheid. Thank you.
Chair, that's the presentation. Maybe just to add, even though it's an old 1973 treaty, Advocate Lugiza in the presentation had mentioned of Palestine being the most recent to sign up in 2014, but other countries that have signed up this century, Serbia in 2001, Moldavia, Paraguay, Guatemala, Honduras, Georgia, in 2005, Montenegro in 2006, and Uruguay in 2012. So it is, states are still signing up, basically, is the point I'm trying to make. Thanks, Chair.
Thank you very much, DM. And thank you, Advocate, for that presentation. Apologies, my throat is not too well. So I hope I'm also audible on that side. Members, it's now time if you have any comments and or questions that you would like to pose forward in terms of the presentation that was made. If you can give me an indication through the raise your hand function, if you have any. I know this is a very, very important international convention and instrument. Members, are there any takers? Okay, maybe I'll just keep an eye out if there are any. But maybe just from my side, DM, and obviously in relation to our own history, you know, it was a very painful history, and obviously my question would be that why has it taken this long for this important instrument, this convention, to reach Parliament? And I know you did indicate that the perception of apartheid was, I mean, given the fact that it was seen as being over, but obviously you also indicate that it isn't. But obviously as a country, you know, in terms of our solidarity with the people of Palestine, for example, this is an example where the people of Palestine, there are high levels of suppression and apartheid practices by the Israelis. I mean, those practices have been going on, and we can't, as a country, also say that we were not aware of this, or that apartheid was over, for that matter. But my question would still be, DM, is why has it taken this long for the convention to reach Parliament? But the fact that it's here, I think that is also an important milestone. Maybe another question is around, in terms of our legal framework, would there be, would this convention impact on any other piece of legislation, and would these need to be amended? And also, I think you did indicate that we are current in terms of reporting requirements, but maybe just give an indication whether if there are any other duties that this will impose upon South Africa post-ratification, and the implications thereof. And on members, if there aren't any other questions, I'm not seeing any indication. Maybe then let me hand over to yourself, DM.
Chair, thanks. I'd like to also ask the DG, just particularly from the time he was in DIRCO, and then I think probably Advocate Lujiza as far as the second question, but also giving an attempt at the first question. But if the GG has any comments, if he can also come in after me. When I came in and the issue was sort of raised with me, why haven't we ratified this treaty? With both treaties, in fact, in terms of our country reports to the treaty body committees, we do get asked, it has been raised by those bodies, concluding observations that we should ratify these two treaties. So it is something that is raised. When I came in, I had asked, but why haven't we ratified it? Was told at the time, I think, by officials in the Department of Justice that no, it hadn't been. I mean, obviously, these are political decisions, so not the decisions of the officials, that it was felt that it had been felt that apartheid had gone, so it wasn't really necessary. However, as I said, there is still very much relevance to ratifying these treaties, and countries are still doing so. And then also, I think it becomes more prevalent with the denialism that seems to have started, the revisionism of our history, that apartheid wasn't actually so bad after all. But if I can maybe ask the DG if he has any points he wants to make, particularly not necessarily in your DG capacity, but in your former life in DIRCO. And then Advocate Lujiza, if she's also got comments on this point, but if she can specifically respond to whether it impacts on any other pieces of legislation. Thanks, Chair.
Thank you very much, DM. It does look like it was just one of those areas that the general feeling was that the country had done enough to deal with apartheid. But if you look at the work that South Africa does internationally, particularly in the area of fighting racial discrimination, I think morally it will just there was a big gap, a lacuna, that South Africa was not a state party or signatory to a treaty of this nature, which in the main was adopted as part of solidarity in support of the South African struggle against racial discrimination and apartheid. So generally, even as international law continues to develop, even apartheid being institutionally having ended in the country. But I think it is very important because the state parties have an opportunity from time to time to meet and discuss developments globally around issues of racism. So I think that gives South Africa an important opportunity to provide that leadership. The world still looks up to South Africa to provide the leadership in the fight against racism in the world. So I think the point that the TM has made is very critical, that we needed to be there. And in fact, when some few years ago, the former president, F.W. de Klerk, when he raised the issue that apartheid was not a crime against humanity, that's when then suddenly this issue came up as well, and it was realized that indeed it was defined as such by the convention adopted by the General Assembly. And in terms of the laws, I mean, Advocate Lujiza can talk about that. I don't know of any law that really has to be amended because in the rest of the other international conventions that deal with racial discrimination, I think there is an alignment. Thank you very much, Chair.
Advocate Lujiza, I don't know if you've got anything additional to say.
Yes, thank you, DM. Yes, in addition to what the DG has said, I think that the country is sufficiently covered in terms of apartheid as a crime against humanity, as I have indicated that we have incorporated it into the implementation of the Rome's Statute of International Criminal Court Act, where it is incorporated in Article 7 as a crime against humanity, and the Convention on the Elimination of Racial Discrimination. So I do believe that we are sufficiently covered in terms of legislation to be able to deal with the obligations that arise out of acceding to this convention. And some of as I indicated, there will be no need to do periodic reports because that committee is no longer active. The other obligation that we will have is to carry out the decisions by the Security Council, which are aimed at preventing, suppression, and punishment of the crime of apartheid. But as a member of the United Nations, we are already obliged to carry out Security Council resolutions anyway. So yes, so I think we are sufficiently covered to be able to deal with the obligations that arise out of this convention. Thank you.
Thank you very much, DM and the officials from the department for your responses. And I think we acknowledge the importance of this convention insofar as it seeks to criminalize and suppress all forms of apartheid. And we note that by agreeing to ratify this convention, we will indeed be acknowledging that apartheid in any form will not be tolerated and that human rights will be upheld. I think with that being said, honourable members, I think in our next meeting, we'll then consider the International Convention further or the report of the committee. I think that being said, we'll then move on to the next International Convention for the protection of all persons from enforced disappearance. And this once again on members tabled in terms of section 231, subsection 2 of the Constitution. This convention was tabled on the 19th of August 2022 in the National Council of Provinces. Okay, no, that's fine. Let me then hand over once again to yourself, DM, to then take us through the presentation. And my apologies for also rushing it a bit because I know, with the load shedding, some members tend to get knocked off the system and they tend to come back, but be that as it may, DM, over to you.
No, thanks. Thanks very much. Again, as before, I'll just say a few words and then hand over to the DG and I think Advocate Luchisa for the presentation. This is a more recent treaty. It's one again that we get asked in the country reports, why are we not adopting? It's on a particularly important issue, which is enforced disappearances. And I think Advocate Luchisa will go through the definition, but enforced disappearances are basically by states or state parties. So it's not normal kidnappings. It's looking and it's aimed at preventing enforced disappearances from happening, and she will go through the details of what's in the treaty. We also need to see this one in the context of our history. So although the convention is looking forward, the apartheid state was responsible for a number of enforced disappearances of people who have never been found, and what happened to them is never been properly known. Some had disappeared. The Pebco people in the Eastern Cape, in the then Port Elizabeth, Simpiwe Mtimkulu, some of it came out in the TRC, what had happened to them, and some remains were able to be discovered in both cases. Some people are still missing, are still disappeared. The NPA has a missing persons task team trying to trace particularly the remains of people who disappeared or find out what happened to them. But I think we need to particularly look at that context. The main street in Pretoria in Tshwane is Stanzibo Pape. He disappeared. It was an enforced disappearance. You've got the Deputy Minister of Cooperative Governance, Deputy Minister Nkadimeng, her sister, Nokuthula Simelane, is still disappeared, has still not been traced, has still not been found. There's an inquest of a disappeared person in KZN starting next month, Sporpewa. So there's numbers of people. So it is we do really have to be conscious of our history in terms of the numbers of people who disappeared. We have been actually wanting to bring this to Parliament for some time, but it's been caught up, I think, largely in bureaucratic problems. You'll see from the list of accessions, that it's other countries have ratified. I think Sudan ratified last year, 10th of August 2021. Slovenia, 15th of December 2021. But it is something that we definitely need to be part of. Luxembourg deposited 1st of April this year, and we are already late about this. But having said that, if I can then hand over to Advocate Mashabane to say some words if you want to, and then to Advocate Lujiza.
I'm covered, DM. Advocate Lujiza can proceed.
Thank you very much, DM and DG and members of the committee. Can we go to the next slide, please? I think we can start on the next slide. The annexures listed, they are all the annexures that were accompanying the presentation. For this next slide. Okay. The convention was adopted in 2006, as the DM outlined, that it's quite a recent convention. And South Africa was very much involved in its negotiation, and we voted in favor of the adoption of the convention. And it entered into force in 2010. There are currently 68 state parties to the convention. And as a country, we've received numerous calls from the Human Rights Council and other committees that we normally deal with as we are submitting our country reports, especially the human rights committees, urging South Africa to accede to the convention, as it will also demonstrate South Africa's commitment to the protection of human rights and adherence to international human rights law. Next slide. The convention, as DM has alluded, it defines enforced disappearance as the arrest, detention, abduction, and any other form of deprivation of liberty by agents of the state or by persons or groups of persons acting with the authorization, support, or acquiescence of the state, followed by a refusal to acknowledge the deprivation of liberty and by concealment of the fate and whereabouts of the disappeared person, which place such person outside the protection of the law. So in a sense, the role of the state is critical in this definition. And this convention is the first universally binding treaty that actually defines enforced disappearance as a human rights violation. The 5 key areas in terms of the obligation of state parties that are contained in the convention is the fight against impunity, investigation and prosecution, prevention and combating of the phenomenon of enforced disappearance, rights of victims, rights of children, their abduction and disappearance from parents who have themselves disappeared. And next slide. The strategic focus is that Article 24, sub-Article 4, states that each party shall ensure that in its legal system, that victims of enforced disappearance have the right to obtain reparation and prompt, fair, and adequate compensation, such as restitution, rehabilitation, satisfaction, including restoration of dignity and reputation, and guarantees for non-repetition. This article does not impose an obligation on the state parties to create a fund for compensation, but it creates an obligation for the state parties to ensure that we create the right environment. That means we have the right legislative, we have the right legislation that will give the victims the right to approach any court to enforce their rights and seek remedies accorded by the convention. So this convention is quite special in that way, that it gives the victims the right to approach a court to enforce their rights in accordance with the convention. Next slide. The convention is quite broad in terms of its protection and scope, and it emphasizes the protection of victims and the rights of family members of the victims. It incorporates the many criminal aspects which differs from other human rights treaties. The Rome Statute of the International Criminal Court already provides for enforced disappearance of persons as a crime against humanity. So by virtue of South Africa having incorporated into our law the ICC statute through the ICC Implementation Act, we have thus catered for enforced disappearance as part of our law. However, the ICC Act, the International Criminal Court Act, it only focuses on systematic and widespread version of enforced disappearance in the context of crimes against humanity. The convention is trying to close the gap that remains there, which focuses on the occurrence of enforced disappearance at a lesser scale, isolated individual cases. And that is what is not covered by the ICC Act. So the convention is trying to close that gap. Next slide. Therefore, this means that the convention will have to be incorporated into domestic law, because on our domestic law, we do not have that legislation that caters for those isolated incidents of enforced disappearance, especially where they are committed or done with the acquiescence of the state. And the offenses that are created by this convention must also be extraditable offenses. They are regarded as extraditable offenses for the purposes of extradition and mutual legal assistance. We have consulted both the chief state law advisors at DOJ and DERCO, and they are of the opinion that this convention is in line with our domestic law and international obligations. And should Parliament approve the accession, we will deposit an instrument through DERCO of accession to the UN. Next slide. We are thus recommending that Parliament approves South Africa to accede to the International Convention for the Protection of All Persons from Enforced Disappearance in terms of Section 2312 of the Constitution. Thank you.
Thank you very much, Advocate and DM, for the presentation. Our members, once again, if you have any questions and for clarity and or comments that you would want to make, please give an indication. Honorable Ndongeni.
Thank you, Chair. I'm sorry, Chair, about my video. I have a challenge of network. I'm sorry for that.
And it's quite all right.
Thanks about. Okay, thank you. Thanks about the. My question is, how will this convention be incorporated into domestic law? What changes are envisaged? Will this convention require additional training of law enforcement officers? If so, how will this be undertaken? Article 24 speaks to victims receiving reparations and adequate compensation. What are the mechanisms that will be implemented to ensure effective enforcement of this article? Thanks, Chair. I'm sorry, Chair, I have a load shedding. I'm not quite sure whether you hear me or you don't hear me.
No, I think we've heard you quite clearly, Honorable Ndongeni. Any other honorable member?
Okay, thanks, Chair.
Thank you. Okay, then maybe just I can add to those questions, DM, just in terms of the of whether, given the various mechanisms that are required for implementation post-ratification, what is the budget that is envisaged for its implementation, if any? And also in respect of enforcement of this convention, which are the departments and or organizations will the department collaborate with to ensure effective implementation, and will there be any cost implications as well? I think that those are the questions also from my side. Over to you, DM.
Thanks, Chair. unless the DG wants to say anything, if I could ask Advocate Luchisa to start, let me come at the end, but particularly the issues of what changes. Some of it I think you've addressed already, Advocate Luchisa, but maybe if you can just go into a bit more detail, and then particularly the chair's question, and then if I can come back at the end, that's unless the DG wants to speak at this point.
Now, I will yield to Advocate Luchisa to proceed.
Thank you, DM. Let me attempt to answer some of the questions. Members will recall that we already have the crime of enforced disappearance incorporated into our law by virtue of the ICC statute. But then now the reason why this convention also will need to be incorporated into our law is because it has these new elements that were not catered for before, which includes also the rights of victims or family members of victims to approach a court and to enforce some of their rights with regards to what is provided in the convention. So that is why we would need to incorporate it into our law so that we create those rights and obligations. And it will be done in the same way when we incorporated the Rome Statute into our law. That will basically be the same process that will be undertaken. And on the issue of training, I'm not sure whether there's new specific training that I suppose security agencies would need to undertake, since the issue of enforced disappearances is already a crime anyway. So I'm not sure whether there's a need for new training with regards to that. But of course, once it's incorporated into our law, if there are elements where perhaps which need training or retraining, perhaps that would then have to be considered by the relevant agencies. I'm not sure if you could remind me if there's a question that I'm not sure of, the enforcement of the article. Which article was that? Chairperson?
Yeah, I think it was Article 24.
It was 24's reparations, and it's the mechanisms for reparations, if any. But I think Advocate Luchisa, you did address that, but just if you could repeat, I mean, when you first made your presentation, but if you could repeat that, that there's not an obligation to form a fund. But yeah, can you just repeat that?
Oh, okay. Thanks, DM. Yes, that article is just making an obligation for the state to make it possible for parties to be able to approach the court to enforce the rights that are contained in the convention. You will notice that it indicates that there's an issue of restitution, rehabilitation, satisfaction, or guarantees for non-repetition. All of those, one can approach the courts to enforce those, and it will be the court that will determine whether the victim or the person approaching the court is entitled to any of those. But because the state is central to the actual, to the definition, to the actual crime of enforced disappearance in terms of this convention, that is why the state then has to make sure that it creates that mechanism whereby parties can be able to enforce their rights against the state. Therefore, the courts would be the best place to do so. Thank you. I hope I've answered.
Chair, maybe if I can come in, or DG, do you want to say anything? DG, do you want to say anything? No, I can't see any response, but let me sort of...
No, DM, my apologies, DM, I don't have any further input.
Okay, thanks, DG. Maybe just to say that we were a country, the apartheid state caused people to disappear. It's part of our history. To some extent, that was dealt with by the TRC legislation, which provided for reparations, not just of people who disappeared, but for all victims of human rights abuses. And that would include extending those rights to those victims' children and even grandchildren, education being paid for at basic education being paid for, tertiary education being paid for. That's the past. And this treaty obviously would be looking forward. We are not, as the South African state, causing any disappearances of people. But the issue is this issue is twofold. One, ensuring that the mechanisms are in place that if we ever have a state that causes people to disappear, that the elements of the treaty are in effect in South Africa. And secondly, sending a message to the rest of the world where people are disappearing. So I don't think, I mean, we would have to look at the law, the laws. There has been some work which you've got already from the state law advisors as to what would need to be amended. As far as the costs, I don't think there's not going to be much happening at the moment because there aren't disappearances, but we need to ensure that the laws are there for if it ever does happen again. I just also wanted to comment, as I'd done with the other treaty, on the countries that have ratified. We are behind in things. In SADC, it is Lesotho, Eswatini, Zambia, Angola, Mozambique, Tanzania. I hope I haven't missed anyone out that have ratified. There's West European countries, France, Netherlands, but then it's interesting the countries that haven't ratified, and it would seem that countries that were involved in renditions during the war on terror have not ratified. So the United States has not ratified. The United Kingdom have not ratified. But there's a wide range of countries, and we're actually behind in our region and on our continent. Thanks, Chair.
Thank you very much, DM and the team for your presentations as well as for your responses in terms of the questions asked. I think that we should also acknowledge that even though we might be a bit late, that by ratifying this convention, we will be complying with its international and constitutional obligations in upholding the best interests of the child and adding an extra layer of human rights protection. I think this is extremely important as well. And perhaps honorable members will also in a subsequent meeting then deal with further observations of the committee and or the report of the committee. But once again, DM, thank you very much, and thank you to your team for making this time to come and meet with us, and especially to yourself as well, DM, given the fact that you're also outside of the country. And I think we appreciate the support we always get from yourself. Thank you very much.
Thanks, Chair. If I can just also then thank the Director General and Advocate Lugisa and Mr. Leso, if he's still on us or he tried. Thanks, Chair.
Thanks.
Thanks, Chair.
I think DM, you and your team can be released also from the meeting. Our members will then go on to in terms of the next agenda items, was in terms of the reports, the two reports related to DIRCO, those international convention and the protocol. And just given that members keep falling off and on the platform, honorable members, I'm going to propose, okay, Keshwan, are the necessary members present? Let me just give me an indication.
Chairperson, I look now with Honorable Dangle present.
Yeah, because even Honorable Motsamaya was on the platform earlier, but I see he's also fallen off. So you said how many we're present currently?
With yourself, Chair, it's 1, 2, 3, 4, 5, 6. I count 6.
No, it's fine. Honourable members, I think given the fact that we traditionally have to be 7 members present, and I'm just going to propose. I mentioned members were present at the beginning of the adoption of the 2 reports to the next meeting of the committee. I guess it's not really up for debate, but I'm proposing that we do that in the best interest, just so that if anyone wants to challenge us in terms of the procedure, we wouldn't want that to happen. I see Honorable Dangle, you're raising your hand. Honorable Dangle?
Yes, I think you need 5 provinces plus 1.
Okay, I think not in this instance. We need a simple majority on this one. Keshwan, if you can perhaps clarify.
Yes, Chairperson. Our previous minutes, we agreed that a simple majority for these matters will suffice, Chair. That's how we've been adopting all our previous matters. But Chair, let me just, I've recounted, and Honourable Ndungeni is on, and Honourable Visser, so that will make us seven members, a majority, Chair.
But Honourable Ndungeni and Honourable Visser have been on the platform since the beginning. I think who has fallen off this platform is Honourable Motsamai. Because I noted he was on in the beginning, and I don't know at what point. But how, you're saying that we're 7?
Yes, Chair.
Okay, no, that's fine. Then let's continue, honourable members. Just in terms of the second agenda item, honourable members will recall that we dealt with the 2 international agreements that were presented to us by the Department of International Relations. The one was, and Keshwan, I'm not sure if you're able to project the report as well. The first agreement was in relation to the Republic of India, the Federation Republic of Brazil, and the Republic of South Africa on the IPSA Fund for the Alleviation of Poverty and Hunger. This obviously tabled in terms of Section 231, subsection 2 of the Constitution. Our members, and I think the report was sent to you previously, and we're projecting the report on the screen once again. And just in terms of our recommendation to the House, we're saying that the Select Committee on Security and Justice, having considered the request for approval by Parliament of the ratification of the agreement between the Republic of India, the Federative Republic of Brazil, and the Republic of South Africa on the IPSA Fund for the Alleviation of Poverty and Hunger, tabled in terms of Section 231, subsection 2 of the Constitution 1996, approves the said ratification. If there's any indication from honourable members on the report, please indicate so. Honourable Denga, I see your hand is up.
I move for that.
Thank you, Honourable Dangle. Any second?
I second, Honourable Chairperson. Honourable Bartlett, second.
Okay,
Chair?
thanks, Honourable
Can
Bartlett.
you hear me?
Yeah, I hear you. Yes, I can. Are there any
Okay.
objections and abstentions? Okay, if none, then our members, the report is duly adopted. We'll then go on to the second report with regard to the protocol to the Constitutive Act of the African Union relating to the Pan-African Parliament of 2014 tabled in terms of section 231, subsection 2 of the Constitution. And just in terms of the report that goes to the House, if I can just read through it, is the Select Committee, having considered the request for approval by Parliament of the protocol to the Constitutive Act of the African Union relating to the Pan-African Parliament of 2014, tabled in terms of section 231, subsection 2 of the Constitution 1996, approves the said protocol. That would be our recommendation. On members, if I can get an indication from members in terms of Maleka.
Thank you, Chairperson. I move for the adoption of the report.
Thank you very much, Honorable Maleka. Honorable Mteto, any seconder? But I see your hand is up, Honorable Mteto.
Ndongeni,
Yes,
seconded.
Okay, I see Honorable Mteto and Honorable Ndongeni second. Are there any objections and or abstentions? Okay. I just see legacy hands, but if there are none, then all members, the report is duly adopted. Let me then take this opportunity to thank you very much, honourable members, for your attendance and participation in this meeting. I know besides the load shedding, quite a few of you are actually also traveling to Cape Town, and I think you took the extra effort to ensure that you're also in this meeting. Thank you very much, honourable members. And that being said, thank you. I think this meeting is declared closed.
Thanks, Chair.
Thanks.
Thank you, Chair.
Thank you.